On May 1st, 2011, the Department of the Treasury activated 31 CFR Part 212. This federal regulation instructed every bank in the United States to stop handing over Social Security deposits to private debt collectors. But the banking industry found a mathematical blind spot almost immediately. They realized the federal protection only applies to the exact routing code attached to an electronic direct deposit. If you move your own money from checking to savings, you strip away the federal shield entirely. If you withdraw cash and deposit it back a week later, the money becomes legally invisible to the government. You lose your right to Section 407 of the Social Security Act. One wrong transfer destroys your federal protection. The bank will drain your account today. The Social Security Act became law in 1935. Congress wrote Section 407 to build an impenetrable wall around retirement benefits. Lawmakers drafted this specific statute to ensure that elderly Americans would not starve because of an unpaid hospital bill or a predatory loan. The statute explicitly states that these federal funds are not subject to execution, levy, attachment, or garnishment. In the 1930s, the government found this mandate incredibly simple to enforce. Retirees received paper checks in the mail every single month. They cashed them at local bank branches where the teller knew their face and their financial history. The origin of the money was never a mystery to the institution holding it. Today, the modern banking system operates on automated algorithms. Chase, Bank of America, and Wells Fargo process millions of transactions per second. When a debt collector files a judgment, a local court issues a garnishment order electronically. The bank receives the order and their software immediately freezes the account. The algorithm does not stop to read where the money came from. It only sees a numerical balance. 30 years ago, a human bank manager would review a garnishment order and manually exempt a Social Security deposit. Now, the machine freezes the account first and forces the senior citizen to prove the money belongs to the federal government. This creates a catastrophic delay for the account holder. The legal protection still exists on paper, but the burden of proof shifted completely to the retiree. Everything changed while the law remained frozen in the past. You fight a digital algorithm with a rule written for paper checks. Raymond is 71 years old. He lives in a brick ranch house in Oak Park, Illinois. He bought the property in 1988 for exactly $115,000. He paid off the 30-year mortgage 5 years ago. He has a small garden in the back and a detached garage that needs a new roof. Raymond receives a monthly Social Security benefit of $1,840. The money lands in his Chase checking account on the second Wednesday of every month. He keeps his finances simple and organized. He pays his property taxes, his utility bills, and his grocery expenses from this single account. 2 years ago, Raymond spent 8 days in the local hospital for a severe respiratory infection. Medicare covered the bulk of the medical costs. A secondary billing department misrouted a claim for a specialized breathing treatment. The hospital sent a $4,200 bill directly to Raymond. He tried calling the billing office, but he kept reaching an automated phone tree. Eventually, the hospital sold the debt to a third-party collection agency. The agency filed a lawsuit in the local county court. Raymond never received the summons because the process server delivered it to the wrong address. The court entered a default judgment against him for $4,200 plus attorney fees. On a Tuesday morning, Raymond logged into his Chase account to pay his electric bill. His balance showed $0. The collection agency had sent the judgment directly to Chase. The bank software froze all $3,680 Raymond had sitting in his checking account. This represented 2 full months of his Social Security benefits. He drove immediately to the local branch. He told the teller the money came from the federal government. The teller apologized and handed him a phone number for the legal department. Raymond needed to buy groceries and his daily blood pressure medication. He called his daughter and borrowed $500 for the week. Then he made a fatal error. He had an old savings account with a local credit union containing $1,200 in emergency funds. He transferred that money into the frozen Chase account, hoping to cover the negative balance and free up his debit card. The moment he did that, he commingled unprotected funds with protected funds. He destroyed his own legal defense. The bank seized the $1,200 immediately to satisfy the remaining garnishment order. Raymond lost his emergency cash and his Social Security money in the same afternoon. The system punishes the exact people it is supposed to protect. The federal shield governing this situation is 31 CFR Part 212. The Department of the Treasury drafted this specific regulation to force banks to comply with Section 407 of the Social Security Act automatically. The rule requires a mandatory procedure called the account review. When a bank receives a garnishment order, the law forbids them from freezing your account immediately. First, the bank must perform a 2-month look-back. The bank must review the account history for the 60 days prior to the exact date they received the court order. They must identify any direct deposits carrying a specific federal routing indicator. Social Security payments, supplemental security income, and Veterans Affairs benefits all carry this electronic tag. The bank must calculate the total amount of federal benefits deposited during that 2-month window. That exact total constitutes your protected amount. The bank must leave that money completely alone. They cannot freeze it, they cannot send it to the debt collector, they cannot charge you a garnishment fee out of those funds. You maintain full access to that money to pay your rent and buy your food. This represents a mandatory federal requirement, but banks routinely fail to apply it correctly. The most common failure happens when a retiree moves their money between accounts. The federal tag only stays on the money in the original account where the Treasury deposited it. If your Social Security goes into checking and you manually transfer half of it to a savings account at the same bank, the savings account carries zero federal protection. The bank will freeze the savings account and surrender the money to the collector. Another massive trap involves the physical paper check. If you receive a paper Social Security check and deposit it at an ATM, 31 CFR Part 212 offers you no protection. The rule explicitly demands an electronic direct deposit. No direct deposit means no automatic look-back. But you must understand a crucial carve-out regarding federal debt. This protection stops private debt collectors from touching your bank account. It does not stop the federal government. If you owe back taxes to the IRS, or if you defaulted on a federal student loan you co-signed for a grandchild, 31 CFR Part 212 steps aside completely. Under the Debt Collection Improvement Act of 1996, the Treasury utilizes the Treasury Offset Program. They bypass the bank entirely. The government takes the money directly out of your check before it even reaches your account. They seize up to 15% of your total monthly benefit. You fight a war on two fronts. We must look at the exact math of the look-back period to understand how this breaks down in reality. Let us examine a retiree named Dolores. Dolores receives $2,100 a month from Social Security. Her money arrives by direct deposit on the third Wednesday of the month. She carries an old credit card debt of $6,000 that a collection agency pursues aggressively. On October 15th, the bank receives a garnishment order from the court. The bank must look back exactly 60 days. The look-back window starts on August 16th and ends on October 14th. During this exact window, the Treasury deposited $2,100 in September and $2,100 in October. The sum of those two deposits equals $4,200. This is her legally protected amount. Now we look at her actual account balance. On the morning of October 15th, Dolores holds $3,800 in her checking account. Because her actual balance sits lower than her protected amount of $4,200, the bank cannot touch a single penny. They cannot freeze the account. Dolores continues using her debit card as if the garnishment order never arrived. Now we change one simple behavior. We watch Dolores make a common, everyday financial decision. She receives her $2,100 Social Security deposit in September. She feels nervous about the debt collectors. She decides to withdraw $1,500 in cash to keep in a safe box at home. A week later, she realizes she needs to write a check to a local roofer. She deposits the $1,500 in cash back into her checking account. She thinks it represents the exact same money. The federal law disagrees entirely. On October 15th, the bank receives the exact same garnishment order. The software performs the same 60-day look-back. The software identifies her October deposit of $2,100 as protected. But she withdrew the September deposit. The $1,500 cash she deposited later carries no federal routing tag. It represents untraceable cash. The system registers her protected amount as only $2,100 for that window. On the morning of October 15th, her account balance shows $3,800. The bank subtracts her protected $2,100. That leaves $1,700 of completely unprotected funds. The bank immediately freezes that $1,700 and wires it to the collection agency. Dolores loses $1,700 simply because she touched her own money and put it back. The math remains brutal and it accepts no excuses. The ledger decides your fate. Moving cash breaks the vital chain of custody. When the chain breaks, the money disappears. This mechanical seizure of funds happens thousands of times every week across the country. The Consumer Financial Protection Bureau reports that debt collection consistently ranks as one of the most complained about financial issues in America. Older Americans hold significantly more debt today than any previous generation entering retirement. Medical inflation, property tax increases, and the rising cost of utilities force seniors to rely on credit cards just to bridge the gap between their fixed income and their actual living expenses. When those cards default, the original creditor sells the debt for pennies on the dollar to massive litigation firms. These firms operate exactly like factories. They file thousands of lawsuits every single month. They do not care if the defendant is a 20-year-old student or an 80-year-old widow. They rely heavily on default judgments. They know that a senior rarely shows up in court to fight a complex medical bill they do not understand. Once the firm secures the judgment, they blanket the major national banks with electronic garnishment orders. They cast a wide net hoping to catch a checking account with a high balance. My name is Walter Barron, and I study these specific financial traps because the system relies on your lack of knowledge. The banks comply with the orders to protect their own liability, not yours. They perform the bare minimum required by 31 CFR Part 212. If a computer system misreads a routing code, the bank freezes the account and waits for you to complain. The burden of proof always falls on the citizen with the least resources to fight back. You are the target. The 2-month look-back rule contains blind spots that collectors exploit daily. The first trap involves joint accounts. If you share a checking account with a spouse who still works, you sit on a financial landmine. If a judge enters a judgment against your adult child for an unpaid car loan, the collector targets the joint account. The bank still performs the look-back for your specific Social Security deposits, but any money your child deposited from their job remains entirely unprotected. The bank freezes the account and drains all the non-federal funds. Your debit card stops working until you unravel the legal mess. The second trap is the right of set-off. This mechanism has nothing to do with outside debt collectors. This happens when you owe money directly to the bank where your Social Security arrives. If you hold a credit card with Chase and your checking account sits at Chase, you signed an agreement when you opened that account. The fine print grants the bank the right to seize money from your checking account to pay a delinquent credit card bill. 31 CFR Part 212 provides zero protection from the bank itself. The bank simply transfers the money internally. They take your retirement funds to satisfy their own private ledger. You must build a firewall around your benefits before a judgment is ever filed. Do not wait for a legal letter in the mail. Take the first step this week. It takes exactly 5 minutes and costs absolutely nothing. Call your bank and confirm that your Social Security codes properly as an electronic direct deposit with the federal identifier. Ask the representative to read the exact deposit code back to you over the phone. Make sure it does not register as a manual deposit or an ACH transfer from a third party. Second, open a dedicated checking account strictly for your federal benefits. Never deposit a birthday check, a pension payout, or a cash refund into this specific account. Let it hold only your Social Security money. Pay your critical bills directly from this protected account. If you receive a pension or wages from a part-time job, put that money in a completely separate account at a completely different bank. This action ensures your federal shield is never diluted by commingled funds. Third, log into your online banking and download 2 months of PDF statements right now. Keep a hard copy in a physical folder labeled Section 407. If a freeze ever occurs, you lack the time to request documents from a slow customer service department. You need the concrete proof in your hands the exact day it happens. Fourth, if you hold an outstanding credit card or personal loan with the exact same bank where your Social Security arrives, you must reroute your direct deposit immediately. Go directly to the Social Security Administration website, use Form SF1199A to change your deposit destination to a neutral, unaffiliated credit union. Cut the internal connection before the bank exercises a right of set-off. Organizing your accounts in this precise manner removes the ambiguity that banks use to freeze your money. The financial system expects you to remain quiet. It relies on the assumption that an older American accepts a frozen account as an unchangeable fact. There are dozens of voices online right now trying to scare you into buying a gold subscription or paying for a masterclass on debt elimination. I do not sell anything. I have no courses. I will never ask you for a credit card. I read the Federal Register and I study the tax code so I can hand you the exact mechanisms you need to protect your own money. The only reason this channel exists is to make sure you possess the information that people inside the system have always had. The only thing I ask in return for this research is that you subscribe to Dark Macro by Walter Barron so that the next video finds you before the deadline does. Drop your state in the comments below. Let me know exactly where you are watching from. Next week, I reveal the exact IRS form you must file when a nursing home tries to place a lien on your primary residence. You possess the legal right to defend your property. Keep your accounts separated. This channel does not offer personalized financial or legal advice.